Welcome to the Republic Podcast, where history meets scrutiny and facts matter. Join Rob and Lou as they dive deep into the foundations of American democracy, dissect the laws that shape our lives, and challenge the narratives behind today's headlines. From forgotten chapters in the U.S. history to the legal truths they didn't teach you in school. This is your front row seat to get informed, unapologetic conversation. We have an American republic, if we can keep it. Now, let's get started.
Hey,
so
back to the Constitution.
And the
Bill of Rights, my brother.
Good to see you and everyone out there. Thank you for joining us again for another episode of the Republic, If You Can Keep It podcast.
If you can keep it.
And
when we were last together, we were talking about the Second Amendment. No controversies or any hot topic buttons there.
Nothing like that.
So we want to give you guys and give everyone out there the idea of why the Constitution and the Bill of Rights is what it is, why it's there. And all of that comes down to context. I've used it all the time. We're going to go through a whole bunch of amendments from the Bill of Rights to the 3rd through the 8th. And the 4th, 5th, 6th, 7th, and 8th really deal with citizens when they go through the court process.
Right.
But we have to touch on the 3rd because, it's right after the 2nd and we don't want to leave it out.
You have to go to 4. 3 is quite out. Sorry.
I was hoping you were going to go there.
Yeah.
That's awesome. All right. So we're going to make this as educational and fun and interactive as we can, as we always try to do. So real simple. We're going to go through the 3rd Amendment, which says, we're going through the text first. No soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. And you're like,
what the hell is that?
What? Remember, they're writing this in 1791, not so long after the American Revolution, where the Crown and the British, wherever they were, would forcibly kick people out of their own homes, or they would kick the colonists out of their own homes to house their own soldiers. Right. So,
it was essentially it was called the Quartering Act for obvious reasons, because they're forcibly putting people in they're providing quarters for their own military at the expense of the colonists. Sorry, but go ahead.
No, so the founders just said, you know what? I was concerned about this, a couple of years back when this was happening. So we want to make sure that our government, because remember, the Constitution is basically telling the government, these are the things that you can do. Otherwise you can't. And also we want to be able to tell you what you can't do in addition to. So they want to be able to put as many reins and as many safeguards in place as possible. Hence the 3rd Amendment and don't quarter, in the house is barring some, whatever act of law that goes on afterwards. So that's real simple.
Not a lot of discussion.
Amendment number 3. Now we really get into the meat and potatoes, because these are the things that really, again, from watching us before, we're 2 lawyers. So these things are right in our wheelhouse. Amendments 4, 5, 6, 7, and 8 are the amendments in the Bill of Rights which deal with persons who go into the court system. How will they be treated? What rights will they be afforded, et cetera, et cetera. And again, with the context that they didn't want to be treated as they were under the Crown rule, with some of the unfair rules and weights that were put on defendants, for example, who were charged with crimes against the Crown, with people who wanted to avail themselves of the courts to have a right to a jury in civil trials to sue over property or money or things like that. So let's get into the 4th Amendment, which is a biggie.
Right.
And as a former prosecutor, Mr. Lou,
Well,
take it away.
so again, the Fourth Amendment is again, and one of the things that people very often don't quite understand is that when they look at the Fourth, Fifth, Sixth, Seventh, Eighth, as well as the 14th Amendment, which we'll also talk, which deals a lot with due process, is that it's confined to criminal courts. And really, it's not. It's whenever the government is taking any type of action against you, and it's an official governmental action, then some of these rights, in fact, many of these rights apply. But putting it into the most common realm that you deal with it is the criminal courts. Fourth Amendment is the privilege against unreasonable searches and seizures, and the sum and substance of it is that people have the right to be secure in their their property, their places, and their person. And so what that means is that the government cannot forcefully enter your house to obtain evidence against you. They cannot force you to give evidence against yourself as far as physical evidence. And that's what the Fourth Amendment deals with, is physical evidence. And
if I can,
yeah, go
real
ahead.
simple. The language really, even though it was written in 1791, you still can understand. It's not like it's some Shakespearean thing where you're kind of, what does that say? Fourth Amendment, the right of the people to be secure, as Lou says, in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. End quote.
Right. And that's where a lot of it comes down to, and that's the key thing, is probable cause is a standard that any governmental agency, any law enforcement agency has to meet in order to get a search warrant to basically forcibly go in and seize items. And a search warrant, depending upon the jurisdiction, is something that can be very simple or very, very detailed. It can go from just back in the old days, back when I first began as a prosecutor, when you're going for a search warrant on a house and you're looking for, it was very sort of generic papers, evidence, it was very, very simple. Nowadays, especially like if you want to get a search warrant for a cell phone or something like that, it's very detailed. And in fact, by case law that's come out in many different jurisdictions, including the U.S. Supreme Court, it has to be very detailed and lay out not just what you're looking for, but how it directly ties back to the crime, the timeliness, why you still believe the evidence is there, and how it, and why you believe it's in this location. So the way that I teach it at the police academy is that the steps that you have to go through is, okay, tell me what you're looking for. Tell me why it ties into this crime that's being alleged, and how it ties into the crime that's being alleged, where you believe it's going to be located, why you believe it's going to be located there, and why you believe it's still going to be at that place. And so that's essentially search and seizure in a nutshell. What you're looking for, all the way down.
Right. And our founding fathers, this was one of the seminal concerns that they had, because in the 1760s, 50s, into the 1770s, when everything started to percolate and the revolution kicked off, the Crown had things called writs of assistance and general warrants, where they would just tell a police officer, I think, there's a crime going on, go get it. Whatever it is, wherever you find it, carte blanche, and they would kick down doors, do whatever it was. And there were some particularly notable cases. One of the founding fathers was John Adams, and he was in a courtroom in the 1760s when, if memory serves me correctly, James Otis, another one of the founding fathers, was arguing a case that there had been a general writ of assistance, which basically attacked James Otis's client, kicked down their door, and James Otis said, "This is wrong. Writs of assistance are absolutely beyond the pale, beyond common law, anything we should do." And when John Adams heard James Otis speak against it, now remember, James John. When John Adams went to Philadelphia, these are in his mind. He remembers this stuff as one of the founding fathers, and he heard the argument that James Otis made against the writs of assistance. And he said to other people, when I heard that argument, I knew the seeds were being planted and the child of independence was soon to be born. I think that was an exact quote.
Yep.
So, and James Otis is the one who coined the phrase in that speech, a man's home is his castle.
Right. Exactly. And that's exactly the point, is where it prevents the government from going in, without probable cause. Now, what's probable cause? Probable cause is defined by case law in a lot of different ways. And that to put it into the spectrum, that you have reasonable suspicion. Reasonable suspicion is that it's more likely than not that somebody has been involved in a crime, and that you're going to find some type of evidence on that. Reasonable suspicion is the lowest standard. That's basically something where that is the basic level where police officers can begin an investigation. And that's the lowest standard. Now, what is reasonable suspicion? Or as it's known now, it's more often known as reasonable and articulable suspicion. That articulable one is very important, where officers need to be able to state and articulate sufficiently what that reasonable suspicion is. Simply saying, oh, because I just have a hunch, that's not enough. But because I believe it, because I've been a cop for so many years and I think he did something. Well, they have to point to specific factors, saying, these are the factors that I know, either through myself, my personal investigation, information other people have provided me or other officers have provided me, where I now have, this is the basis for when I believe that this person has committed a crime or is about to commit a crime. And so then you could go in, and what can you do? Then you could detain, you could do what's called a Terry, again, everybody knows a Terry frisk. Stop and frisk. That's based on reasonable articulable suspicion. Say again?
Terry frisk.
Woo! Terry frisk. Yeah, it's frisky. Yeah. And that from there, you can that for anyone that's never has never experienced a frisk isn't like the kind, gentle thing that you see on TV. It's pretty thorough, and it's designed to be that way because it's there to protect the officer and the people around them. So, from reasonable articulable suspicion, what else can you do? You can detain a person for as long as necessary to either confirm that reasonable suspicion and continue on to probable cause, or from there, if you can't do it, then you say, thank you very much, go on your merry way, and continue on your investigation. That probable cause means it's more likely that you have the next level up, where it has to be at least at and the thing is, I hesitate to even give any type of actual number, because there's really no percentage. In fact, courts specifically say it's not something that we can say that we can quantify and say it's a 75% or it's a 69 1/3%. It's where a reasonable person standard, looking at that same facts and that same circumstances, would believe that a crime has been committed, that evidence is located in that area, and that's where it can be found. So it's that reasonable person standard, which is defined by case law across all the country. And so that's really what you need. And that's protecting American citizens from people from the government. And it's not just police officers. It could be any agent of the government from kicking in your door and taking whatever they think. And it prevents also, I'm sorry, I don't mean to go off on a tangent, but it also prevents people from going into the house and, okay, I'm going to search your entire house, where it has to be limited, where we usually in law school, you would hear the analogy, you can't look for an elephant in a bread box, where you can only search in areas where you think the evidence could be found. So if I'm looking for a big screen TV, I'm not going to open up a drawer inside a dresser, hoping that I'm going to find a big screen TV there. But if you're looking for something like narcotics or now thumb drives, anything like that, the smaller it is, the more that it gives you the ability to search everywhere. Where I've been, parts of searches where we've actually gone up into ceiling tiles because there was indicia that something might be in the ceiling tiles to find narcotics. So anyway, go ahead.
And for everyone out there, understand that the Fourth Amendment was written in 1791. So we talked about kicking in someone's door to do a house search. With technology that's developed, especially in the 20th century, there's been case law that comes out and they want to make sure that people understand that the Fourth Amendment protects people, not just places.
Right.
So when there was a case in 1967, I think it was Katz versus United States,
Right.
who that hurt pulling that one out.
Yeah,
Oh,
I know.
that's old. That's just like 30 something years ago from law school, pulling that one out. Where, if I remember correctly, the gentleman was in a phone booth. If those of you who remember what a phone booth was,
Yeah.
and the government put a tap on the phone booth, he had a reasonable expectation, even though he was outside of his house, he was outside of his office, he was outside of his own car. He had a reasonable expectation once he closed the door to that phone booth of privacy. There were other cases now that talk about GPS tracking. When you have your cell phone out, it pings off of different towers and you can be tracked however you want. Is that legal? Do you need a warrant for that? All of these things now, it's more than just, what happened when the Brits kicking down doors in Boston in the general area in the 1750s. Now we've got a whole bunch of things, but the Fourth Amendment protects you against improper seizures and searches, and it's supposed to protect the people, not places.
Right. Right. I mean, like Rob was saying, anyone that still that carries around one of these, that I don't want to say Big Brother is watching, but Big Brother is watching everything. Any app that you have gives you, that's why when you're downloading these apps, they actually have those terms of use and everything else that actually lays out what law enforcement has access to and everything else. And, as I teach in my classes, you have that cell phone. If you have your same account that you had when you bought your first iPhone, your first Samsung phone, or anything else, I could go back all the way back to that original one and see what you were doing 10 years ago when you first bought that iPhone. If you haven't, if you still have everything connected and have all, and haven't taken the steps like I do to block certain things like that. But I mean, this is something where we're going to go into more of a riff session about all this afterwards, to really flesh these things out. But we just want to get the meat and potatoes of what these amendments mean and how it really ties in. Because talking about this now, I'm just realizing that there's so many different rabbit holes that we could go down that we're going to give a good overview.
Lou will be the first to tell you because he still teaches this stuff. But I remember being in law school, going to criminal law, and the Fourth Amendment took up a couple of weeks.
Right.
So you can really get into the weeds about it.
Right.
This is an overview. We want to let you know how it came about, why it came about, and what the importance of it is. And it protects all Americans, all citizens, because those concerns stem all the way back to the founding fathers and what happened with general writs of assistance, etc.
Right. Then the next thing that we have from there, going on from the Fourth Amendment, is we have the Fifth Amendment. So what is the Fifth Amendment? The Fifth Amendment is a right against self-incrimination, and it dates back to the Magna Carta and the protections that the Magna Carta have. And it's really what it is. It's that you cannot be compelled to provide testimony against yourself in any type of governmental setting, and that can go anywhere from, anytime that there's any type of possibility of criminal repercussions, that you cannot be compelled to give a statement. And I'll go into some different details about that, about employment laws and stuff like that. But that's the sum and substance of it.
There are that's the main substance of the Fifth Amendment, but there are two other aspects of it which are sometimes overlooked.
Right.
One is the fact that if you are brought up on federal criminal charges, the government has the obligation to present it to a grand jury first.
Right.
Which is not insubstantial. It's not just they get to write and charge you and off to court you go. They need basically, and for those of you who don't know what a grand jury is, it's a panel of citizens who are impaneled to hear the government come in and say, this is why we think that these charges should be issued. And they have the right to say you didn't meet a burden. So it's not, like I said, it's not insubstantial. And then also at the end of the Fifth Amendment, it talks about, I'm looking at the right now. Nor shall private property be taken for public use without just compensation.
Right.
Which has, you might think, what are you talking about? But it's actually become much more of a sensitive issue in recent years. There have been some seminal cases that have gone to the United States Supreme Court where the government, whether it be the federal government, whether it be the state, whether it be a town or municipality, says, this farm over here, this house over here,
Eminent
this
domain.
estate over here, we're going to take it because we want to put up, a casino. We want to put up something that generates revenue for the city. We want to put up a park. We want to put up low income housing, whatever it might be. And we'll determine what we give you. Here's 5 cents, and some belly lint. No. There are some significant repercussions that have come up. Much of what has been in that particular clause from the Fifth Amendment it would come up time and again, but it really started to be used in the interstate when they finally put in the interstate highway system in the 1950s, and large swaths. Where do you think were the roads when they just had nothing there? No, there were neighborhoods, there were towns,
Right.
there were villages, there were farms, and that clause where the government had to pay out starts coming up. There was just a case in New Jersey.
Right.
I think it was outside Princeton or Cranberry, New Jersey. A farm which had been in a family since the 1700s. The town wanted to take and give minimal compensation for, and this guy fought it and fought it and fought it, and finally the town backed down. But there's a lot to talk about with that. But the main gist of the Fifth Amendment is what Lou said. I mean, I'm talking about the two other items in the amendment which are important, but the main thrust of the amendment, where the meat and potatoes of it comes from, is what Lou was talking about.
And I mean, the whole thing that the whole reason why the Fifth Amendment came about is also because back in Old English days, back in the UK and even in the United States and the colonies, came from the Star Chambers, where you would have a group of people that were appointed by the governor of the colony or by the crown, and they would basically hold these hearings, and that they would force these people to testify and say, if you do not testify, if you do not provide, as they call, if you do not clear yourself, then you're basically presumed guilty, which we'll talk about later on. And that then that's where, they could go in and seize your property as part of a governmental effect. And that's why the whole grand jury thing came about, where many states have different versions of the grand jury. Connecticut, we didn't, we were in the few states that didn't have a grand jury. We operated by what's called information, where that it would come down to, like myself, like as a prosecutor or other prosecutors, we'd review the information. And if we found probable cause, we would sign that and then present that to the judge to make a further finding of probable cause. So we didn't have a grand jury, but it met the Fifth Amendment requirements because there was at least a independent source where you had to have basically the prosecutor find it, and then the judge. So you had another judicial authority find probable cause. But most states still operate by that. If anybody, if anybody has an opportunity, I would highly recommend. I mean, people are like trying to get out of jury duty as much as possible. Be part of that process. Just at least see what it's like and see how the system actually works. Or just go into court and sit in court for a day and just observe and really see, because it's really, it's eye-opening. But so
I'm gonna get on my high horse just for a second.
Giddy up.
Giddy freaking up. It is every citizen's civic duty.
Right.
When you're called to serve for jury duty, so many times people come in and they whine and oh my God, this is part of being in a free society here in the United States. It isn't just you take and take and take. You have to participate in it. And part of that is when you're called for something like jury duty, that's part of your civic duty. And both, and I'm laughing because both Lou and I had clerked back in the day at the criminal court, and we saw, and we would handle jury panels for cases that were going to trial. And I can't tell you how many times on what they call voir dire, which we'll get to at another time, when we're trying to impanel a jury, people who were potential jurors would make it sound like this was the biggest problem in the world. I can't be bothered with this.
Right.
I have better things to do. No, because
We would
if
have
you're
judges
on the
that
other
go
end
off
of
on them,
things,
actually.
if you're ever brought up on charges and you're brought into court as a defendant, you want a jury there for you.
Right.
So
Right.
when the shoe's on the other foot, you're wondering why people are trying to shirk it. When you get called, go in. I'm getting off my horse. Fifth Amendment.
No, and one of the common misconceptions about Fifth Amendment. Okay, everybody knows Fifth Amendment, Miranda rights. Miranda rights, you have the right to remain silent. Anything you say can be used against you in the court of law. You have a right to an attorney if you cannot afford one will be appointed for you. And it you see it on TV. And everybody's like, here's the one thing, and here I'm going to get my horse for a second on this. Everybody, as soon as they see somebody interacting with a police officer, they're like, they didn't read their Miranda rights. Well, here's the thing. There's certain requirements for the Miranda rights to attach. And we're going to flesh this out again in the next episode when we go into the riff session and we have a full discussion on some of these things. Because that for the Fifth Amendment, for the Miranda rights to apply, you have to be basically in custody. It has to be considered in a custodial interrogation. So if I was a police officer and I was just having a discussion with you on the street, that's not something where anything you say at that point, if you're answering it, then that's on you. And they're like, well, there was 5 police officers around them and all these things. And it's like, okay, well, then you have to take a look at the what else they do to basically impose their will against this person. Because the whole Fifth Amendment issue is that you are overbearing somebody's freedom where they feel that they have to answer this. They're being compelled to do it. And that's not accurate. That it's something where, you could have situations where 5 officers around them, but so long as there's no other show of force or show of authority, that's fine. You can have one where one officer is there, and by the mere fact that they're putting their hand on their weapon, that becomes now a custodial interrogation, and that could change things.
Right.
But anyway, so Fifth Amendment, right against self-incrimination. Basically, you have the right to shut up if you choose to. If you're dumb enough to talk, then that's your fault. That's an easy way to remember it.
Fifth Amendment, as a wrap up. The founding fathers remember the Magna Carta, and they want to make sure that the government doesn't have overreach. So if you find yourself in the courts of this country, or that there are protections from the legal processes.
Right.
Rights against self-incrimination. There's due process clause about trial, having a grand jury. Government can't seize property without just compensation, and there's no double jeopardy. Can't be charged twice for the same crime.
Right.
All right. Little
Cool.
bow on Article 5. Amendment 5.
Yeah. Fifth Amendment. Next, we have the
Now
Sixth
we're on to
Amendment.
the 6th.
So what's the language of the Sixth Amendment there, Rob?
I will tell you. I'll bring it up in just a sec. The Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and the district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense.
Right. And that's another one where it is just, it sounds simple, but it's not. There's so many different, it's like peeling back an onion, like, what is it, Shrek? It's an onion, you peel back. The more layers you peel back, the more that it just really, there's just so many different layers up to it. So the Sixth Amendment, basically the bottom line is You have the right to be told what you're being accused of, the crimes that you're being charged with, and then that the state actually has to call witnesses. We cannot just rely upon, and it's got to be witnesses that are credible, truthful, reliable,
And you
and
have
meet
the right to cross-examine.
right. And you have the right to cross-examine them. Now, one of the things that's different, which ties into the Sixth Amendment, as well as we go into the Eighth Amendment or the Seventh Amendment, Eighth Amendment, and 14th Amendment, which all deal with different due process and things like that. But the main thing about the Sixth Amendment is that in other countries, especially over in Europe, it's not that you have the right, you're presumed innocent. That in the United States, you start with the presumption of innocence. That's basically part of the Sixth Amendment. You're presumed innocent until the point where the government proves you guilty after trial, fair and public trial with witnesses and things like that. In other countries, it's the exact opposite. You have to prove your own innocence, that you're presumed guilty, and that you have to prove your own innocence to a certain standard before the government then comes back to prove that you're guilty. So you have to carry forward the burden of proof to a certain level to show at least somewhat of your innocence. Years ago, I mean, the big case that came up was that case in Italy when you had the one woman who killed her roommate and was brought to trial 3 different times, and that was at the standard. She had to show that she was innocent before the government then had to come forward again and show that that she was guilty of these crimes. But in the United States, it's completely different.
So, like Lou said, I mean, we talk about the history and the context of this. There used to be, before the revolution, these star chambers, and the government would
Right.
have a very heavy hand dragging people out of their homes. This is what you're doing. We're charging you with this. You didn't have the right to know what you were charged with when you were being apprehended and confined. You didn't have to, you didn't have the right to confront the people who were making the accusations against you.
Right.
People just say, he did this, and then that was it. You didn't get to cross-examine them. You didn't get to try to tell the judge they're full of crap or whatever it is. And you did not have the right to your own representation. You were out there by yourself. The Crown had all the resources and the prosecutors to do what they needed to do. The Sixth Amendment was very, very
Right.
revolutionary for the world, stemming from our revolution. It ensures a speedy trial. It ensures that you have the right to know the charges that are against you, to confront the witnesses and people who accuse you of this, this, and this. You have the right to obtain witnesses, meaning you can subpoena people to come into court, and you had the right to trial. Huge.
Right. Right. I mean, and that people think that the right to trial, that's something that's been around for a long period of time, and it's really not. Where it was before, for the longest time, that it was just simply felony charges. That anything that was misdemeanor or below, which means that, and the difference is felony is anything that's more than 1 year incarceration as a possibility. Misdemeanors are anything 1 year or less. And that some states have played around with the definitions and things like that, but that's the main differentiation. For the longest time, if you were charged with a misdemeanor offense, you were not entitled to a trial by jury. It was by judge only, and it wasn't until the Supreme Court made other rulings to say no, that you were entitled to a jury even for misdemeanor offenses, and like them for the representation. Everyone's like, well, what do you mean that you didn't have right to an attorney? That it was Gideon versus Wainwright. And that's another one pulling it out. That
Wow.
that that said that you actually have the right to an attorney on these criminal cases, and that if you can't afford one, that the government has to appoint one for you. That they can't force you to represent yourself. Essentially, like somebody that's. And I would always explain it to our pro se defendants when they're like, "Oh, I want to represent myself." I'm like, "Okay, listen, not for
That was
nothing."
after Lou started laughing, like,
Yeah. And I'd be like, "Okay, listen. That is your complete right. You have your
right.
total right to do that if you choose, and I cannot prevent somebody from doing that. But just so you understand, I've been doing this for however many years. I was trained in trained in law school and trained in how to file motions and how to argue things in court and what the standard of proof is and everything else. And it was actually my obligation as a prosecutor to explain to them, this is what would happen. And these, these are the things. And just on a side tangent, I'm going to go off on a little story here. One of the trials I had was a drug trial, and the defendant was represented by a very able attorney, but he didn't like the way that his attorney was going about with the case. So, middle of trial, he fires his attorney, and the judge had to question him, and he questioned the defendant, and the defendant's like, "Yeah, no, I understand, and I want to go and do this on my own." So he gets up and he calls himself as his first witness. So, and Rob, you can already understand where I'm going for with this. And he explains as a running serial statement, saying, like, basically just giving a statement to the judge. And so then I have as a prosecutor in this, I have the right to cross-examine him, because once he made himself available to testify and he chose to testify, then he could not stop and say, "Okay, I'm done talking. I don't want to talk anymore." Once you begin testifying, that's it. You have to answer the question. And so he gets up there, and I start, and I know what I need to prove, and I know what the standard is. And so I started asking these questions. Well, you didn't bring the drugs there to sell. You just came there to party, and like, you were giving the drugs to people, knowing that that's all they needed to prove, is that he didn't have to actually get money. All they had to do is just transact with somebody and give it to somebody. Yeah. And you didn't mean, like, and you went to this house intentionally because you knew this house was a party house and that's where you wanted to be, right? And you saw that it was within 1,500 feet of a school, but it was a party house, and so you went there because there was other people there that were partying there, and not knowing that by him admitting that, yes, he went there and intentionally went knew it was within 1,500 feet, exposed himself to greater liability. And so at the end of that, and that after we go through what's called the jury instruction, because the jury's there, and he's listening to the judge explain it, like, as we're discussing it, and he's like, "But that's not right." And the judge is like, "Well, but that's what the law is. And that's what I tried to explain to you, and what Mr. Luba tried to explain to you, but you chose to go off on your own." He's like, "Can I get a redo? Can I have him do it?" And the judge said, "Nope, that's not how it works. Sorry, bud." And he ended up getting convicted and got sentenced for a long period of time because he was stupid. Anyway, so that's Sixth Amendment story.
Sixth Amendment ensures a fair and speedy trial, right to know your charges. You can confront your accusers. You can obtain witnesses, the ability to obtain witnesses, and guarantee representation.
Right.
Sixth Amendment, all those rights weren't there before. Founding fathers did. Put pen to paper.
Right.
God bless them. Well, we're going to go real quick through the Seventh Amendment because it's really, really kind of
right.
It's brief. It basically guarantees and continues the right for jury trials in civil cases. If you want a jury trial, you should have it. You're entitled to it. It reflects the historical importance of jury trials. Always had been in earlier times, and the founding fathers wanted to maintain that. It protects individual rights against arbitrary government actions, against property, against money, against whatever. You have the right to a jury trial in civil cases. That's Seventh Amendment.
And again, this deals with governmental action. So for the governmental action where they're going after your property. So again, criminal is separate, but if it's an eminent domain or a similar taking case, that's where you have the right to a jury trial.
Now we have the Eighth Amendment.
Yeah.
And the Eighth Amendment, as I was reading and going back and refreshing my memory of some of the stuff, because I wasn't a criminal law attorney when I was in practice. But from my notes back from law school, which I still have, that's a whole different level of crazy, but there it is anyway. I remember writing down the Eighth Amendment is to protect and reflect society's views on humane treatment, to prohibit the government from overly hostile penalties and overly hostile actions against someone who has been charged with a crime. So it prohibits excessive bail and excessive fines, and it prohibits cruel and unusual punishment. So, as Lou the prosecutor laughs.
So, I mean, the whole thing is the Eighth Amendment, the Sixth Amendment and the Eighth Amendment go sort of hand in hand, because the Sixth Amendment you have the right to a public and speedy trial. And so the key word in relation for the Sixth Amendment to the Eighth Amendment is speedy trial,
Right.
because the Eighth Amendment is against excessive bail. And so you see a lot of the things that are going on right now. You have these criminal justice reform bills where they're changing the bail bond structure, where bail is designed to require, going back historically, it was required for a surety or somebody to be able to put forth money to say, yes, we want this person out of jail. We are willing to put our house up to guarantee that this person will actually return to court if you release them from jail pending a trial. And so it's a way where, it prevented the government from holding people indefinitely waiting for trial, because back in the day, it could be years. And in fact, now, in most of the court system, the way that the courts are so backlogged, you could be held waiting trial for 1, 2, 3 years sometimes, or more, depending upon the situation.
Right.
And there's a lot of rules that come into play there. So, before you jump on me and say, well, Lou, that's not fair. There's a lot of different ways to calculate it and other things like that. But so the Eighth Amendment prohibiting against excessive bail means that the courts cannot set a bail or bond so high where it prevents somebody from getting out of jail completely. And then people are like, well, what about like the $1 million bonds that are set for some of these people? Well, you take a look at a lot of the different things. Take a look at the person's criminal history, their ties with the community, the seriousness of the crime, other things like that. Those are the main ones where the court takes a look at that to say, okay, well, the person doesn't have significant ties with the community. This is a heinous crime, and that the likelihood of them fleeing to avoid trial are so significant where if somebody's going to be putting forward money or surety or something else to get this person out of jail, we want a significant incentive for them to make sure that this person shows the hell up in court.
Right.
But that's where, so the Sixth Amendment and the Eighth Amendment tie in together on that, where you want to make sure a case goes to trial quickly, and that you want to make sure that, that somebody is not held and unnecessarily in jail waiting trial.
Yeah, and the language of the Eighth Amendment really is brief. It says excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
Right. And I mean, you've had a lot of challenges to the death penalty where death penalty is overturned because it was considered cruel and unusual. There's a lot of different things that were considered, where, there's been challenges to cruel and unusual punishment, but that's mainly where it falls in, is the death penalty type of cases.
Right.
But yeah, so I mean, those are the main amendments that deal with the governmental, I'll call it the governmental, although it's mainly the criminal court process. It's a governmental court process. Whenever the government takes an action against somebody, either in criminal or civil court, that these rights apply.
Right.
And, this is something where we really have flown through these,
I
because
was just going to say, we, in the span of what, 40 minutes, we've gone through Amendments 3, 4, 5, 6, 7, 8.
Right.
And like I said, just on Amendment 4 in law school, that would take us weeks to peel all the layers of the onion. So we want to give you the context, where it comes from and why it's important. But, at the same time, we don't want to belabor it, go through on this case.
And, it may be something that, because for the classes I have for Fourth Amendment that I teach at the police academy, that it would be a week-long class, 5 days from 8 to 5 in the morning. I mean, 8 in the morning or 5 at night, all day. So just picture hearing me talking that entire time. Yeah, I'd shoot myself too. But there may be some that, there may be some sessions that I have that I might be able to put on as an additional, little primer for what the Fourth Amendment really is, and some of the excerpts from my classes. We'll have to discuss that.
Right.
And if that's what you'd like, let us know, because
I was just going to say, we want this to be interactional. We want to be we're trying to give you, as we said, we want to educate people, because people don't understand just the basics of what's going on the foundational documents. We're going to get into the history of the country. We're going to get into the people who drove the history. We're going to get into all that stuff, but you got to know the foundational pieces first as the foundation before you start building on it.
Right. And if it's something you
for all
want to,
those out there who want to comment, please do.
right.
Comment, subscribe, like this video, please.
And just to let you know, we did have a comment. Somebody commented about my flag and how unkempt they were. So I ironed this one specifically for today. So for the listener, you know who you are out there. It's done now. You better? All good? Thanks.
Well done. Well done.
So with that being said, again, we appreciate you being here with us. We do this for you. We enjoy the interaction. Let us know what you want to see. Like, share, and subscribe. That's the main thing. That we, as of this recording, we are now at almost 200 subscriptions. I've made that requirement where I'd like to hit 500 before the end of the month. So please help us out.
We really appreciate the input you guys have been giving. We appreciate the support. Keep going. Share this with people.
Yep.
Like it. Learn it. Love it. Live it.
Exactly.
That's what we say. And
So,
we're going to
cheers to you, my
continue on
brother.
with the Constitution next. And we're going to roll into some very, very important amendments.
Yep.
13th, 14th, 15th, among others. So
They're
buckle
all
up.
important, but these are the ones. Yep. Yeah, right. So cheers to all you out there. Cheers, brother. Great
Cheers,
seeing
brother.
y'all. And we'll see you next time.
Right.
Shut up and sit down.
Thanks for listening to The Republic, If You Can Keep It podcast. Join Rob and Lou in our next episode as we continue our riveting discussions on the most important topics affecting our great republic. Drop a line for topics you want to discuss, and don't forget to like, subscribe, and share. Until next time.